Hi, Frank Carney here. I'm Washington, D.C. Lawyer. We handle serious injury cases and especially people who've been denied long-term disability after a serious injury or illness. So I've got 7 quick tips of what to do when you've been denied long-term disability benefits, by your employer's long-term disability carrier, Unum, Guardian, Lincoln Financial, Hartford, or perhaps you have a personal policy. The 7 tips are the same. Here we go. Number 1, get a complete copy of that claims file. For the people we represent, we request about 27, 28 different things, categories, to make sure that we get the entire claims file. And sometimes that claims file is, anywhere between 500 and 1,000 pages or more, depending on if you've been on claim, depending on how many physicians you've seen, how the case has been worked up, how many experts the long-term disability carrier has. But you've got a right to that under ERISA. ERISA is the federal law that governs almost all of these long-term disability policies. It's the Employee Retirement Income Security Act. If you request that entire claim file under ERISA's regulations, they've got to give it to you. So make sure you get that. Number 2, study the policy, okay? You should get your long-term disability policy. Study that because the terms, the conditions, the periods of benefits, all of those things, how they define your occupation, all of those things are going to be critical in trying to put together your appeal to show that you're entitled to long-term disability benefits and to give to other experts and physicians that you'll be working with in connection with your appeal as well. So study that. That policy governs everything going forward at that point. Number 3 is a job description. Write your own job description so you know exactly, and talk to others about it, exactly what's been going on. A lot of employers just have sort of a vague job description about their duties and responsibilities of the position. They don't really say how much you have to lift and carry, for example, or if you have a real cerebral job, the cognitive functioning that you need to make decisions quickly, that you need to work under pressure, that you need to multitask, those kinds of things. You want all of that down on paper so that you can use that with your physicians, with other experts that you'll probably need in connection with your case. Next, number 4 is work with your doctors, and this is critical. You've got to understand your policy terms and definitions. What does it mean to be disabled under your specific policy? You've got to translate that for the physician that you're working with, for your treating doctors, so that they can articulate that, so they can have a basis for the restrictions, a basis for their opinion, saying why you can't work or why you can't engage in that type of work anymore, okay, and the restrictions and limitations that you have. That's critical. I mean, we recommend setting aside time with your doctor, and your doctor may charge you for it, or any specialist that you've been referred to go through any insurance company forms that they need, or to answer sort of the questions under the policy, okay? You may not know what those questions are. We help people with that a lot, to match up the policy with the specific opinions that are needed, specific medical opinions. Number 5, get statements from your coworkers, from your friends, and of course from yourself. And there's a real art to doing this. A lot of what we do is we help people tell their story of what it's like, what it was like before and then after this significant medical condition or serious injury where they can't work anymore. Now, that's really something that you want to do early in the process to get people involved in that, to really tell your side of the story. Now, a word of caution, I mean, a lot of the ones that I see where people have written themselves, there's just a lot of bitching and moaning in there, and that doesn't matter at all, okay? There's a specific way to write these in a fashion that's going to be helpful. Because remember, your appeal is basically the framework. It's all the evidence that's going to be used to decide the case. They've got to consider it, okay? And if your appeal is denied and you file your case in federal court, because ERISA is a federal law, that's what a federal judge is going to be looking at to decide your case. Everything that was in that, it's called the administrative record, everything that was in that appeal, all the evidence, your appeal, your statements, all of that stuff. Number 6, get the right experts. We see this time and time again. You may need a specialist because of your condition, who can really help, define the condition and the limitations and the restrictions and why you can't work because of this. You may need a vocational counselor who can match up the restrictions and limitations you have with the ability to do the job. So you really want to be thinking about that from the beginning. Getting the right experts involved in your case can be critical. If you have an MRI, maybe you need a radiologist or a neuroradiologist if it's a brain MRI. Those types of things can make or break a case. Number 7, get the right lawyer. You want someone who's experienced, hardworking, and will tell your story, who really gets it, who's going to take the time to go through your claim file, who has the resources, has contacts with other experts that you're going to need, and can work with you every step of the way to guide you through this process to stand up to the insurance company. Now, I'm Frank Carney. Those are 7 quick tips for what to do if you've been denied for long-term disability benefits. If you're interested in working with us, if you'd like us to review your denial letter, we'll do that for free if you just send it to us at info @dkllp.com. Fax it to us, 202-393-3324, or just give us a call, 202-393-3320, and we'll get right back to you and get you squared away with a plan on how best to proceed for your specific situation. Thanks.